Greetings, everyone. This is Attorney Sharif Silmi. I want to today just jump right into it because I have a lot to cover with respect to how to successfully file for a green card, otherwise known as basically adjustment of status. So and this is specifically pertaining to an individual who's already in the United States. So that person is in the US, they're either in a non-immigrant employment status, they may have entered on a visa and overstayed a visa. They may still be in a visitor situation. So there's all kinds of scenarios where this will kind of help you have more information and understand better what's going on. So let me try to back it up and kind of give you the full overview. So there are essentially three broad areas of immigration within the US system. There is humanitarian-based immigration, which is for an individual, for example, that may be concerned about leaving the US and being persecuted if they are returned to their country, or someone who is a victim of abuse in a spousal relationship or a victim of crime, something along those lines. Those are called humanitarian-based categories. Then there are family-based categories. So that includes immediate family relatives, such as one's parent, spouse, or minor children. Those are immediate family relatives, or the other family relative categories. So it can be, for example, a sibling, or if one is themselves an immigrant and has a green card, and they are petitioning for a spouse, that also does not come under the immediate family relative category. It comes under a different family category as well. The third major area of immigration is, of course, employment-based immigration. So I'm going to just kind of take you through a few scenarios within the immigration process so that we can advise and let you know how that goes. My first bit of attention is going to be in the employment-based scenario. So where one is petitioned for by an employer, they basically have filed what's called an I-140. So an I-140 is an immigration petition for an employer. An employer is filing it on behalf of an employee beneficiary. So that employee is the intending immigrant. So the employee and his or her derivative beneficiaries, meaning his or her spouse and children, have now an opportunity to file for what's called adjustment of status. So adjustment of status is completed using what's called Form I-485. So the Form I-485 adjustment of status is what is filed. And when one files the I-485 adjustment of status, he or she may also file for an I-765, which is an employee authorization document, and an I-131, which is called advanced parole or permission to travel. So these are a few of the form numbers that are associated with one's application to file for a green card or an adjustment of status. Now, that person who is employed by a company needs a very, very important document, and that is called an I-485 Supplement J. An I-485 Supplement J is a bona fide permanent job offer confirmation. This is now required at the time of adjustment of status. So many of you out there who, for example, have been sponsored by their employer at a later date, so initially your employer, what they're going to do is they're going to file what's called a permanent labor certification when they first start the process to kind of get you into the system, to make sure that the job that they're offering you, there's no US citizen workers who can work the same position. And then at some subsequent period, they're going to file what's called Form I-140, which is the actual immigrant petition on your behalf. Now, they can then file, once that's approved, or perhaps concurrently, and I'll get to that, meaning at the same time, they can file for an adjustment of status. So not only do you need your employer to file for your petition at an kind of early date, that your permanent labor petition, but at the end date, they're also going to have to confirm that you have an I-485 Supplement J bona fide permanent job offer. This is really, really important to know, because basically when you're an employment-based category, you're really at the mercy of your employer. So employees are definitely at the mercy. Immigrant employees are at the mercy of their employer, unless they are filing in one of the two self-petition categories. That is national interest waiver, which we went over 2 weeks ago, or an EB-1A, which we went over last month. So either of those two categories do not require a bona fide confirmation job offer. They do not require an I-485 Supplement J. So if you're filing an I-485 adjustment of status based on an EB-1A or based on a national interest waiver, there's no I-485 Supplement J. Better news than that, there's no longer a I-944, which was the proof of financial capacity. That was put in place by the Trump administration when they were seeking to implement what's called the public charge rule. So that public charge rule has been thrown out, and folks who are filing for their green card adjustment of status based on an employer sponsorship or self-petitioning no longer are required to file Form I-944. This is really, really good news, because as you know, those of us who are in the immigration law field understand that documentation requirement was enormous for the I-944. You had to submit credit reports, you had to submit proof of financial income, your educational background. So many things were there, and it was making the adjustment of status a very onerous situation. So that is really bad. Now, with respect to the employment-based categories, all right, one of the biggest issues in adjustment of status is always going to be whether you have filed, or whether you have your filing date current. So basically, there are several categories of employment-based immigration. There's a third category, EB-3, EB-2, second category, or EB-1, which is the highest level or first category. So before you're able to adjust status, you need to check if your filing date is current. So I'm going to just pull up really quick the actual filing date bulletin. And this is the bulletin that we all go to in order to determine whether we are in a position to file for the adjustment of status. Now, you find it at travel.state.gov, or you can just Google State Department Visa Bulletin and you will get it. Now, here's what happens is once you go into this, you're going to find that there's a current visa bulletin and an upcoming visa bulletin. So the present period that we're in March will have an indication of not only whether the filing dates are initial filing dates and what month they're in, final action filing date, but USCIS will also inform us what bulletin we are to use. Let me show you what I mean. So I'm going to go into the visa bulletin for March. And once we go into this visa bulletin, you are going to see what's called final action dates from employment-based cases. And you can also see right here that there's a note that a lot of people overlook. And it's really, really important that we understand the difference between a State Department visa bulletin and what is actually required in order to adjust status. So those of you out there, particularly folks who are on a visa backlog waiting to adjust status, you already have an approved I-140 and you are just waiting patiently for the day that you can adjust status. I'm sure you are probably checking this State Department bulletin every single month. Now, the thing is that if you are present in the United States and you intend to get your green card through an adjustment of status, this bulletin is actually not the controlling date. The controlling date is provided through this link right here, where it says uscis.gov, visa bulletin info, et cetera, et cetera. So when you're filing your adjustment of status, you actually have to go to the USCIS date and see what bulletin are they using. Because in some instances, USCIS will use the final action date from the State Department. And in other instances, they will use the initial filing date. And we saw this, for example, in November 2020 and December 2020, where they said, you know what, rather than use the final action date, we're going to use the initial filing date. And this actually opened up a window for a lot of people who had approved I-140s in second and third category that were waiting in line to adjust status. So that is very, very important for you to understand that the controlling document is not the State Department bulletin. The controlling document is the USCIS determination of what bulletin they are going to use. And you can see here for March 2021, they have used, this is family-based, so they have used final action dates. So if you are, for example, from India, first category, like an EB-1A or an EB-1C, a multinational manager or an executive, individual of extraordinary ability, or an outstanding professor or researcher, this is your date, August 1st, 2020. That means that if you filed your I-140 prior to August 1st, 2020, you can now file your adjustment of status packet, which is I-485, application for a green card, I-765, employment authorization document, I-131, document for advanced parole. What is advanced parole? Advanced parole is permission to travel while your green card application is pending. Because if you file your I-485 and you do not have advanced parole and you say, I have to go to, you know, whatever, back home because there's a wedding and et cetera, you have, congratulations, just ruined your I-485 adjustment of status application because you've left the country, you've abandoned your application, unless you actually did file for I-131 advanced parole. The good news is, as of right now, this is, you know, being obviously taped live, March 17th, 2021, the I-131 and I-765 applications are included in the same fee as the I-485, which is $1,140 plus an additional $85 for your biometrics. So just understanding of the filing dates is critical for anyone who is interested in filing for adjustment of status based on employment categories. Now, when we think about the family-based categories, there are some, you know, really important considerations to make. So if you're an employment-based person, you still want to pay attention because I'm going to kind of do a general thing as well for everyone. But just these are particular issues with employment-based adjustment of status. So I want to talk about some particular issues with family-based adjustment of status, and then maybe just have a few, you know, discussion of a few things about just the general overview of adjustment of status. So when we're looking at the family-based adjustment of status, note that if you are filing for an immediate family relative, that is you're a U.S. citizen, or you have a U.S. citizen relative that's filing for you. So a U.S. citizen is filing for their parents, their minor children, or their spouse. There's no need to worry about when is my date going to be current. You can file for your what's called I-130, which is an application for an immigrant relative, you can file your I-130. And this person, there's actually special rules for immediate relatives. So if an immediate relative is in the United States, they basically have maybe entered as a visitor and just, things changed while they were here. So when you enter as a visitor, normally you are issued a period of stay for about 6 months. So while you are here, you then while you are here, you then decided that you are not leaving, right? For whatever reason, you decided to stay. So now that you have stayed in the United States, you've overstayed your visa. The only way to overcome that, if you are filing for an I-130, immediate family relative petition as a spouse, a parent, or a minor child, there are special rules that allow you to overcome that overstay situation. So it does not matter that you have overstayed your visa from the standpoint of adjustment of status. If you are an immediate family relative, i.e. a spouse, a parent, or a minor child. Now, note something that's very, very important. If you are a spouse of a green card holder, this is called category F2A, spouse of a green card holder, and you have overstayed your visa, that is a problem. You cannot adjust status. Or if you are a sibling relative, I mean, it's called immediate family, but the other categories are also family-based immigration. It does not allow one to adjust status if you have overstayed past your lawful period presence. So that is very, very important. So if you have basically now here's one thing that's again very important. Right now, the F2A category, which is spouse of a permanent resident and parent of permanent resident and minor child of permanent resident, that category is current. Okay, so that means that if you are physically present in the US, if you are in good status, like you're a visitor that has not overstayed, or you have just some other form like a student visa, for example, and you are married to a permanent resident, a person that has a green card, that person may file for your immigration and you can immediately adjust status. Right now, that is the situation. Why? Because the visa bulletin allows it. So if we, again, think about that, and I will pull up the visa bulletin if I can figure out how to do this again. There we go, but we don't want this window. Yes. So here we have the family-based category of visa bulletin. But look, remember, we're not going to depend on the actual State Department bulletin. We're going to go to the USCIS date, and you see here, family-based, March 2021, F2A, current, no matter where you're from. As long as you are a spouse, parent of a permanent resident, a person with a green card, they can file Form I-130. And at the same time, you can file Form I-485, Form I-765, Form I-131, which is green card application, employment-based authorization, and permission to travel. So this is true, but what do you need? You need to have entered the country legally, meaning you have not entered without inspection. So if you entered without inspection, that's a problem. You need to have lawful status. So you could be a student, you could be a visitor, you could be as long as you have any kind of lawful status, you're fine. You can, for example, that could be problematic. And under those circumstances, you spouse or relative of a green card holder can adjust status right now, right this second, in March of 2021. So this is very, very, very important. Now, again, if we think about an immediate relative of a, meaning a spouse, parent, or minor child of a citizen, it doesn't matter what your status is. As long as you entered the country with inspection, you must have entered with inspection. So for example, if you entered on a B1, B2 visitor visa, okay, and you came to the US, you intended to visit, maybe attend a family reception or wedding or whatever, and then something changed. You had a change of heart, or you met a significant other. You met somebody and the relationship developed. You can actually, even if you've overstayed your visa, you're out of status completely. And you worked without authorization just because you needed to survive. It doesn't matter. You can still adjust status. All of that is excused under special rules pertaining to immediate family relatives of US citizens, parents, spouses, minor children. So these are, very, very important considerations. Now, those same special rules regarding whether you've worked or maybe, fell out of status apply to humanitarian-based categories as well. So a humanitarian-based category is, for example, a person who is a beneficiary of a U visa. So a U visa is a person who's been a victim of crime and is assisting the authorities in investigation of that crime. So there's a certain list that qualifies for that. And if you are a victim of a crime, you should definitely, seek some sort of status based on that situation so that you can adjust status, based on a U visa. The other one is very, very important, is based on what's called VAWA. VAWA is the Violence Against Women Act. And note that under the equal protection laws, that the Violence Against Women Act applies to both men and women. So any man or woman who has been abused by their US citizen spouse or permanent resident spouse may apply under VAWA. And that abuse can be emotional abuse. It can be physical abuse. I mean, we've had a case of an individual who came into the US on a fiance visa. He was emotionally abused by his, then he was married, and he was emotionally abused by his wife. And she was constantly, threatening him that I'm going to get you kicked out of this country. You're going to leave. You have to obey my orders. Otherwise, you're going to have to, go back and, to where you came from. This was documented, and we were able to successfully, after she divorced, or they were actually separated but still married, we were able to petition under VAWA, Violence Against Women Act, for this gentleman, and he is, now free to live without the emotional abuse that he was experiencing. So, these are very, very important tools to consider. So, whether it's employment-based immigration, family-based immigration, humanitarian-based immigration, these are the means that you have available. This is kind of like the vehicle that you are using to immigrate. So now that you have a vehicle, whether it's an immediate family relative petitioning for you, an employer, or you're self-petitioning as a national interest waiver, or an EB-1A, or you have a humanitarian-based immigration petition, now you are adjusting status. What does it mean to adjust status? It means that you are going from being a non-immigrant to an immigrant, okay? And by the way, some work visas, employment visas, are called dual intent. So they are non-immigrant, but you can still use them to adjust status, such as an H-1B, an L-1A, and the like. So now that you have sent your adjustment of status, you are a pending resident, okay? So under the special rules that are designed for pending residents, you are going to be issued an employment authorization document. The time it takes right now is roughly about 4 months. It can vary. Sometimes it's taking longer. And it used to be, I think, prior to the Trump administration, and even in the first couple of years of the Trump administration, it used to take about 2 months, 2 to 3 months. Now with COVID and just the backlog of cases and all that, it's probably taken about 4 months or so for you to get your employment authorization document. That is a very, very, very important document, because once you have your employment authorization document, in that application, the I-765, you can also apply for a social security number. So you'll get your employment authorization card, you'll get your social security card, and you are now able to participate in normal economic activity and work normally and live a completely normal life. And that employment authorization document that you get after filing your I-485 packet will also have on it, if you've also filed your I-131, which you definitely should, because there's no extra fee. The same fee for applying for a green card allows you to apply for the employment authorization document and the advanced parole. So that will have a line on the EAD, on the employment authorization document, that says that you have permission to travel outside of the US. So you can exit and re-enter the US on that advanced parole document. Very, very important to use the advanced parole, because if you don't, you've abandoned your application, and that can be very, very problematic. The other thing that will happen after filing for I-485 is that you'll be called for a biometrics appointment. So a biometrics appointment is an appointment at a local USCIS service center. They'll take your fingerprints, they'll photograph you, and that will put you in the database, confirming your identity, if you will, and as one step in the process. Now, the last step in the process of an I-485 will be the interview. So the interview in the case of employment-based immigration is still required right now. I would stay tuned and see what is going to happen with respect to that. It may be that the interviews are no longer going to be required. That was included in a letter to the Director of Department of Homeland Security by the immigration attorney, cooperative. So we'll see what happens there. But when you do have your interview, it's nothing to worry about. I mean, it's not a re-adjudication of your I-140 in the case of an employer sponsor. It is basically an I-485 interview. And they'll go through those steps, like, have you, for example, been a member of a, terrorist organization? Do you intend to practice polygamy in the US? All these ridiculous questions will be asked, and you have to answer them honestly. And at the very end of that process, you'll be, granted and approved for your green card. That is for employment-based categories. For immediate family relatives, particularly spousal petitions, you must attend the interview with your US citizen or permanent resident spouse. You will be asked about your marriage relationship. This is an interview to confirm that you are in a real marriage. So they will ask you all kinds of questions, whether you've lived together, how long you've lived together, how you met, what are the names of the spouse's parents and siblings, whether you, had children from previous marriages, what are their names, dates of birth. They'll ask lots of questions to make sure in their minds that this is a real marriage. So that is all the kind of steps that are taking place with respect to the adjustment of status and application for a green card. With respect to the employment-based categories, when we want to file a successful adjustment of status or green card, we need to pay close attention to the filing dates. And if we are depending on an employer, we need them to file I-485 Supplement J. If we are in a family-based category, we need to be cognizant of that interview and make sure we're prepared for it, that, we have kind of thought through what it's going to be and answer all the questions so that we can satisfy the government officer and be successful in our overall petition. So, I hope this was helpful to give you a little bit of insight into the green card application process. This video is intended for information purposes and education purposes. Do not act solely based on the information provided in this video, and do not fail to act solely based on the information provided in this video. Feel free to contact us to get more information, 443-329-2929, or at info@silmilaw.com. And always be safe, and we will see you soon.